City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear and make decisions on requests for variances and exceptions from the regulations in the zoning ordinance, conditional uses and appeals from any decision of city staff in the administration of the zoning ordinance. The members of this board are citizens of the city and have been appointed to the board by the City Council. The board members are volunteers and receive no compensation for our public service. So I'm going to introduce the board members who are here, as well as city staff. On the audience's left, we have Cindy Smith and Marlis Jones. On the audience's right, starting from the end, is Justin Gross, Dave Gare, Lynn Carlson. The board chair, Mel Pins, is absent today. I'm Nathan Blake. I'm the vice chair and serving in kind of in his stead. As far as staff on hand, our legal counsel, Judy Parks Cruz, is to my left. We have three city planners sitting in the front row: Bert Drost, Eric Lundy, and Catherine Dostart. Sue Ann Donovan, our zoning enforcement officer, is here as well. This is an open and informal meeting. It's being recorded. The board members have each received a copy of the agenda and the staff recommendations associated with each item. Copies of these agendas and the staff recommendations are available in the trays by the door that you most likely walked in if you want to step up and grab one. The board is required to base its decision in each case upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case is identified in the written staff report. If the facts, as determined by the board, demonstrate that the criteria established by law for granting the relief have been satisfied, then the board must grant the relief. Otherwise, the board must deny the relief. Each appeal will be announced in the order that they appear on the agenda. When an item is announced, staff will give an overview of the appeal and distribute any written comments received prior to the hearing. Then the appellant or their representative will be allowed up to 10 minutes to present their appeal. Anyone else present in support of the appeal will then be allowed up to 5 minutes each to provide their comments. After that, anyone present in opposition to the appeal will then be allowed up to 5 minutes each to provide their comments. The board will then ask any additional questions of staff before giving the applicant 3 more minutes for rebuttal or other closing comments. All speakers are requested to speak from the podium and begin their presentation by giving both their name and address. All speakers are requested to remain courteous and focus their comments only upon those facts that demonstrate whether or not the criteria established by law have been satisfied. Speakers are also asked to ensure that they are respectful of time considerations. If necessary, the board chair will limit further comments by a speaker if they exceed their time limitation. The board will then close any further public comment on the agenda item, and the board will then immediately deliberate the request and make a decision. Please note that it takes at least 4 affirmative votes for any zoning appeal to gain approval. If your appeal is approved today, we ask that you wait until next week to go to the city's Permit and Development Center to obtain any necessary building permit so that the decision of this board can be documented in the form of a decision and order. Any appeal that is approved by the board must be implemented, constructed, or otherwise utilized within 2 years of the date of the decision by this board, or such approval shall expire. Items listed on the consent portion of the agenda, which today I believe is the first 4 items, they will not be individually discussed and will be considered for approval in accordance with the recommendation in the staff report unless the appellant does not agree to the conditions recommended by staff, or if there's an individual present or a board member that requests that the item be removed from the consent agenda so that a full discussion on the matter can occur. The decisions of this board can only be appealed in district court. If you believe you have been harmed by an error made by this board, your only remedy is to seek relief through the district court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the City Council to change those regulations. All material, written or otherwise, used today as part of any presentation will become a permanent part of the record and will not be returned. You may contact staff after the hearing if you need a copy. Handful of housekeeping items. Please avoid conversation in the audience to limit distractions during the hearing that is in progress. Please ensure that your cell phone has been silenced or turned off. If you need to use a restroom, you can leave through this main door, stay to the right of the stairs on this level, past those stairs. The restrooms will be on your left. Once the agenda item that you are interested in has been completed, you are welcome to leave the meeting, or you're welcome to stay. It's pretty fun. There will be a 5-minute break in the meeting around 3 or 3:30 if needed. I'm very hopeful that today's agenda will not necessitate that, but we'll see. I think I'm just going to check with city staff to see if there's any changes that need to be made to what's been passed out.
Sure. Mr. Chair, members of the board, Bert Drost, planner for the city. We have 4 items currently on the consent agenda. We did not receive any opposition to any of those. Then we also have item number 7, an appeal at 801 Southeast 28th Street that staff is recommending be moved to the consent agenda as well. And that would take a motion and a vote by the board to move that to the consent.
So what Bert is saying is the item that's listed as number 7 is been proposed because there's no opposition that's been stated, and I assume that the appellant is fine with the conditions that the staff has kind of proposed. We're going to try to move those to the consent agenda. And the consent agenda we handle all together. We'll take one vote to handle all of them. It'll be an approval just based with the restrictions as laid out by staff. That said, if there's anybody here who wants to speak in opposition to number 7, if you could raise your hand right now. All right, seeing none, if there's a member of the board who wishes to make a motion.
Mr. Chair, I'll move to move item 7 to the consent agenda.
Great, a second?
I'll second.
Thank you, Lynn. All those in favor, raise your right hand, say aye.
Aye.
Looks like it was unanimous. And now we will consider the consent agenda. So again, what we'll be doing is I'll read through each of these more specifically so you understand exactly which item I'm talking about. But the idea is we're going to vote on these as a block. We will be voting for approval subject to the staff recommendations. There's sometimes conditions on what's been requested. And so if you're the appellant, you need to be okay with those. And if you're someone who came to oppose these for some reason, we're going to try to elicit your kind of hand raising for each item so we can actually have a full hearing on the item if needed. Item number 1 is in the vicinity of 1100 7th Street. It's a special permit request by DMAC. Is there anybody in the audience who would like to move that from the consent agenda to have a full hearing? Opposes the appellant? All right, moving on to item number 2, which is an amendment of a conditional use permit at 215 East 3rd Street. Anybody in the audience who wishes to oppose that or speak about it? Item number 3, another conditional use permit. This is at 1433 Walnut Street. Anybody in the audience who wishes to comment or oppose that? Item number 4, amend conditional use permit at 322 East Court Avenue. Anybody in the audience that wishes to speak on that? And just to double check, item number 7, we did just move that to the consent agenda, but that is a variance request at 801 Southeast 28th Street. Anybody here to speak on that that feels like that should not be approved? All right. I would entertain a motion to approve these subject to the staff recommendations.
So moved.
Thank you, Justin. Any second?
Second.
So, any discussion on this? All right, all those in favor of approving items 1, 2, 3, 4, and 7, subject to staff recommendation, raise your right hand and say aye.
Aye.
Aye. Unanimous? Thank you very much. If you were here for any of those items, as I mentioned at the outset, you're free to leave. Your request has been approved, subject to the staff recommendations in the board. As I said, if it has to do with building, we ask that you wait till next week to kind of check with the office to get started on all of that. And we'll move on to item number 5, which is an appeal determination at 3323, or in the vicinity of 3323 Ingersoll Avenue. Sue Ann.
Chair, members of the board, Sue Ann Donovan, Zoning Enforcement Officer for the City of Des Moines. I would like to begin with a request that the board not hear the item on parking. They were sent a notice on December 17th of 2018, which will be entered as Exhibit 9. That was the document that should have been appealed from regarding the parking situation at 3323 Ingersoll. I heard nothing back until January 22nd of 2019, should be exhibit number 10. At no time did they request an appeal of that determination. They didn't request the appeal until January of this year. So I would request that the board, under its rules, cases before the board, every appeal or application or decision shall be directed within 10 days of the date of such order and determination. I did, in my letter to them, set out their appeal rights, so they were made aware of those, not just by reference to the Zoning Board of Adjustment rules of procedure. So I would like that to be considered and discussed before we get into the rest of the case.
So you're suggesting that we make that determination before we hear from the appellant?
The appellant could certainly speak to that as to
Okay.
why they didn't.
But this is a preliminary matter that you want us to
Correct.
talk about? Okay.
Yes.
Um,
I don't believe that the appeal was timely, and I don't believe it should be heard. There was no request for an extension on the appeal time at any time that we've discussed this case, and there was no granting in any way, shape, or form that the city said that we would withhold and let them appeal that determination at a later date.
on the parking side. And so even if we determined that your read of this is correct and it's not our position that the appeal was not timely filed and we have to reject it, there will still be another part of this that we'll go through after that.
Correct. The other part would be
Okay.
the dumpster enclosure portion.
Well, do you have anything else to add on that point beyond what you've proposed or
No,
kind
I
of
believe
presented?
that's-
Okay.
It wasn't timely filed. I'm
Sure.
asking it not to be heard.
I will ask for then a rebuttal from,
Can I ask Sue Ann
Sure.
a question real quick? Sue Ann, so did they not provide any sort of reason or good cause for the untimely appeal?
No.
thanks. So I'll ask for the appellant to come up, and I'm not sure how much time oh, not the whole 10 minutes, because that would double.
Right, yeah.
Maybe like 5 minutes to address this particular issue, and then we'll kind of make a determination as a board and then move on from there, if that makes sense.
Yes, that's fine. David Ginger, Bell McCormick Law Firm. I represent AHC Woodland LLC, which is the owner of 3323 Ingersoll. I have two issues with staff's waiver argument. The first is I really think it's a question of whether staff can cite an inapplicable city code provision that doesn't apply and then get the benefit of a 10-day waiver period. I really think there needs to be some good faith basis in the provision being cited by staff prior to that 10-day appeal period starting. And if you look at the provision cited by staff in its December 2018 letter, it is section 134.1352. Now, by its clear language, it only applies to our district. My client's property is NPC district. It simply doesn't apply. Now, more importantly, I think there's a misunderstanding between staff and my client on what my client is appealing. The decision made in the December 2018 letter was that my client abandoned a legally non-conforming use. That's not what my client is appealing today. My client is simply requesting the board and the staff consider the applicable provisions of the city code and realize that it has always been in compliance with the parking requirements required under the code then in effect. And if you look at the applicable provisions of the city code for parking in the NPC district, you're going to come to section 134915. And what that says is, in lieu of specific off-street parking requirements for a property located within the NPC district, in lieu of specific off-street parking requirements, new construction and remodeling within the NPC district must comply with the site plan design guidelines. Staff has not alleged that my client's property constitutes new construction or remodeling. My client's property doesn't constitute new construction or remodeling. And even if it did, you need to go to the design guidelines to determine the number of off-street parking. And when you move to the design guidelines, again, it's clear that my client is in compliance with the code as it was in effect. The design guidelines, the applicability provision states that in acting upon any site plan application for property located within the NPC district, my client hasn't filed a site plan. Until a site plan is filed, there are no parking requirements for NPC property. So I don't think the staff's decision that, or argument that my client appealed or waived its ability to appeal is correct. I would also note that in the second portion of this subsection A, there's a built-in procedure to reduce off-street parking requirements in the NPC property in the site plan process. If site plans in NPC property go to the Planning and Zoning Commission, and if any one of these 5 subsections is established, then the Planning and Zoning Commission has the authority to reduce the design guidelines applicable to the property. So again, I don't think waiver applies. The staff doesn't have a good faith basis in the provision it's cited in support of its position, and we're not arguing that we retained a legally non-conforming right. We're simply saying we're in compliance with the code as it's in effect.
I think what we're looking for is why didn't you reply within the 10 days? You're arguing why we should have it. I think we need to know why should we allow you to hear this when we didn't have, when you had 10 days to say, hey, this doesn't apply to us.
Yep, I think 2 reasons. One is I think that, again, I'm not appealing the December 2018 letter. I'm appealing something else. And 2, I would ask the board to look at the date that December 2018 letter was sent. It was sent 8 days before Christmas, and we did respond to that letter a month later. Now, it wasn't within the 10 days, but we did respond to that letter. It was outside of 10 days because it was sent 8 days before the Christmas holiday. But again, we're not appealing the letter, we're appealing something else. So the waiver doesn't apply.
I guess I'm confused.
Are there other questions? So I feel like you started off with this procedural point, and I frankly still don't understand exactly what you're saying, because it seemed like what Lynn just said, you moved into the substance of the argument, which we really want to focus on the procedural point, I think.
Nope,
and if you could explain a little bit better.
So the decision made, so the staff says that we had to appeal the December 2018 letter within 10 days, or we waived the argument.
Right.
The decision that was made in that December 2018 letter was that we abandoned a legally non-conforming use. To be a legally non-conforming use, you have to be out of compliance with the code. We're not saying that we have a legally non-conforming use. We're simply saying we're in compliance with the code.
But it's a premise underlying the letter. So regardless of whatever it is that you're appealing within that letter, whether it's the ultimate determination or the underlying rationale, the deadline is still 10 days, is it not?
To appeal the decision being made, but I don't think the decision made in the December 2018 letter was you're out of compliance, and here's why you're out of compliance. I think the decision was simply you lost a legally non-conforming use. Okay, so if we don't have a legally non-conforming use, what's required? I think it's required we come into compliance with the code as it's in effect.
Well, isn't it both? Isn't it both that you're out of compliance and you've lost legally non-conforming use?
Impliedly, perhaps, but I don't think we should imply what the zoning enforcement officer's decision is. I think we should look at the December 2018 letter, determine that what that was. And in any case, I still think we need to analyze the code to determine what was required. Zoning enforcement officer maybe had determined that we were out of compliance, but what does that mean? Does that mean that the staff gets to set the off-street parking requirements Or does it mean that we have to look at the code that's in effect to determine what the off-street parking requirements are?
I guess either way, you're appealing something out of the substance and the message that was received in the letter. And you were on notice from that letter that the city was taking a particular position on both of those points.
I guess I'm confused at then what my client's remedy is. Does it have to come into compliance with the code as it was in effect?
I think whichever aspect of the letter that you're taking, that you're objecting to, it's just, you would need to do it within 10 days as per the code.
Correct, I agree with that. That's fine. And after that 10 days, let's say, sorry, I don't think I want to pose a hypothetical to the board, but if my client failed to appeal within 10 days, I think the requirement would be, okay, now you have to show that you're in compliance with the code. And I think that's what I'm doing here, is I'm saying this 10 days may have occurred, but we're in compliance with the code. Right, so if we look at what's required for parking an NPC property, this is the provision that applies. And I'm just simply saying, zoning enforcement officer staff, you made a decision that we lost a legally non-conforming use, that we're out of compliance. It didn't say that you have to have 10 parking spots. It didn't say you have to have 15 parking spots. It said you need to show that you are in compliance with the code. And that's what I'm doing today. I'm showing that my client was in compliance with the code.
I guess what I'm hearing, though, is that that argument could have been made, though, if you followed the procedures correctly.
If
I mean,
would've
we're just trying to
appealed
get
within
through
10
that.
days.
We're trying to get through that first door, which is, was this a timely appeal, right? We're not even getting into the substance of the matter.
It's, if you take it to a thing, if you were called into court to do something, even if you were innocent and you didn't show up, you're arrested. And this is where there was not an appropriate reply. You didn't reply within the 10 days saying that we are in compliance, or I don't understand your letter.
Okay.
And the law is the law.
So I like that analogy because you say the law is the law. So if I don't make an acknowledgement to the court within that 10 days, the law is the law, right? I still have to comply with the law. I'm in compliance with the law. So if I don't apply within 10 days, I might have not applied within the time period set forth under the requirements, but that doesn't mean I'm in violation of the law. We still need to look at what the law is to determine the off-street parking requirements.
That may be a question of what body does that, sir. What the board is looking at is the article as to when its cases are to be heard, and it requires 10 days in order to have a matter heard by this board. So you are correct, members of the board, in analyzing this. There's a preliminary question as to timeliness of wanting to bring that argument to you, and then if it had been brought timely, what you would get to hear. But we are still at that preliminary question of whether we get into the merits of this or not.
And that's kind of what I was going to say as well, that it does seem like while you may have theoretically some argument to have with respect to whether you were in compliance or not, the idea that we would talk about the substance of that letter back and forth and the substance with respect to parking seems untimely for this board rather than district court or something else. But I'm certainly open to hearing. I don't know. Do you have any other? Does anybody have any questions for the appellant? Do you have any kind of a wrap up?
I would just
1 minute.
Again assert that the decision in the December 2018 letter was my client lost a legally non-conforming use, and that's not what my appeal is trying to set forth.
Thanks. This is a little different than our normal procedure, but I am going to let Sue Ann come up to talk. And if we do that, usually let the appellant go last. So they're probably going to have a rebuttal time, a short rebuttal time. Is that,
She brings it forward, but
Well, didn't the zoning enforcement officer bring this to us?
Yeah.
Wouldn't this be her rebuttal?
this is her rebuttal,
yeah, we don't, even then, though, we don't normally,
usually.
no, if it's like a determination of a zoning officer's, like an appeal of a zoning officer's determination, we usually let the appellant go last.
Yeah, but I think she's the one that brought the agenda item to us. We allowed them to come up to speak for some clarification. She gets rebuttal because you didn't have to let them even speak.
Yeah,
I guess, I don't know, it doesn't matter to me.
okay.
Chair, members of the board, you can decide procedure.
Yeah.
I do have a couple statements to make. The determination on December 17th of 2018 in Exhibit 9 was specifically that they lost illegal nonconforming rights to off-street parking. They would have had to bring in a site plan, which would have been reviewed under Chapter 82, which you don't have authority over. They have never, in the year that I've asked them, brought in a site plan for us to consider what relief they may need to provide the off-street parking. They've been repeatedly asked for that. They have failed to bring that in. It's not my job as a zoning enforcement officer to tell them how many spaces they have on the site. It's their job to hire somebody to draw a drawing and bring it into us so we can say you're X number of short on parking. They didn't do that. They didn't appeal that. They have not appealed that. And you can't hear anything under the Chapter 82 provisions of what the site plan needs. So they have lost their right to the appeal. And it was in here that they've lost the legal nonconforming rights. If they wanted to argue back then that they hadn't lost the legal nonconforming rights, that would have been the time to argue it.
Well, I think the argument's slightly different, isn't it? The argument is that they were still in compliance.
Then they should have appealed that determination and come to you and said, we are in compliance, we have not lost our legal nonconforming rights, or some other argument under the code that would say they hadn't lost it, but they didn't do that. They haven't done it in over a year of continuing back and forth where I've repeatedly asked them for a site plan to be reviewed. They've never come to you at all until we told them they needed a dumpster enclosure, and then they tried to pile everything in on the dumpster enclosure appeal.
So you didn't
Okay.
contact them for site plans after that letter, and they didn't
I've been
respond?
in communication with them. A number of emails have gone back and forth over this property. If you recall, this is the property where the apartment sits on one lot, and they sold off the back two lots to the residential units, and then came in 6 months later with an easement
Yep.
to provide that back to them. But they did not timely appeal this.
Thank you. I am going to give the appellant another minute or so.
This was the same, yeah.
Thank you, Chair Member, members of the board. My name is Nate Barber. I'm located at 2833 Forest Drive in Des Moines, Iowa. I am an attorney at Bell & McCormick, and I represent the landowner here. I think we need to start with the emphasis that we are not appealing the December letter. Whether this property is legally conforming or legally non-conforming is not at issue. The question is whether or not there's any parking. So we're not appealing whether or not, it doesn't matter. For purposes of the discussion that we're having right now, that's the centerpiece of why we did not waive anything. We are not appealing that determination of legally conforming or legally non-conforming, and the staff just said that that's what the letter was about. That's not what we are appealing. So we would ask that we go to the merits of this discussion, because the question is what is the parking requirement in NPC district? That's what we want to discuss. But those parking requirements have nothing to do with whether or not it's legally conforming or legally non-conforming. It's not a rule that if you're legally conforming, your parking requirements are this, or if you're legally non-conforming, your parking requirements are this. So again, I can't emphasize enough that I think there's confusion that we are not appealing what the staff is saying that we're waiving, that we waived, which is this letter that was sent that says that you're legally conforming, or that, I'm sorry, that you lost your legal non-conforming status. And again, if there's confusion, please let us, we should be allowed to at least go forward and present our merits and to discuss that. But to shut it down based on this idea that we waived our argument, it has nothing to do with legally conforming or legally non-conforming.
Well,
Why didn't you respond within 10 days? I don't get to wait and not pay my mortgage if it's due over a holiday.
Yeah, thanks.
It's
No,
due on a day.
Yeah, I'm sorry. There's been a lot of response back and forth, and I think there's been a lot of discussion with staff on this property and those discussions. So there were responses shortly after receiving that and discussing and saying that we disagree with you, that we don't, but we didn't feel like because the code says that there's no parking in an NPC district, and that's what we'd like to discuss, what we'd like to get to, but that's why. But it's not that. They didn't mention the waiver argument until we got this maybe three weeks ago.
But there was a notification in the letter that said you respond within 10 days.
Correct. And
It sounds like you guys ignored that.
No, I don't like that. We had discussions, my client had discussions, sent it to us and asked, and, we said there's no parking requirement in NPC district. So whether you're legally conforming or legally non-conforming doesn't affect the parking requirement. So you don't need to appeal that determination. We have issues with on this dumpster enclosure and other issues, but we don't need to appeal something we didn't feel like we need to appeal. So.
But doesn't that deserve a response back to the city then, saying we don't feel like this is an issue? Rather than ignore Sue Ann's letter for 30 days?
No,
because I think that's her issue.
Well, to bring it into another analogy, I got a letter from the IRS saying they wanted audit on my taxes on the 23rd of December. I had, 20 days to respond. It didn't count that it was a holiday. It didn't count that I was in the right. I still had to respond legally and according to their form. And that's what we're saying is you have not responded to that, and to bring it up now with the dumpster is not appropriate. So what we should be hearing today is just the dumpster, because the parking issue is something else. We shouldn't even be hearing that today because the 10-day thing has resolved, and I guess if you need to go to court for that, you need to go to court for that, but that time has lapsed to discuss parking.
Yeah, again, the letter, again, like David mentioned, the letter says that we lost our legal non-conforming use. It doesn't say that what we say on parking is the rule. It doesn't cover. I don't think the scope of what they asked us, and that's not fair to say that we should have appealed general parking when all it said was that we lost our legal non-conforming use, and that's at most what they could say that is waived in this case. So, but that's.
So I think one thing you said certainly resonated, and that is that there is some confusion here, which I think will remain. And I have a feeling what's going to happen. I don't want to speak preliminarily for the board, but I have a feeling what's going to happen is that we're going to vote to uphold the determination that you have waived the right to discuss this letter, and then once we get into the substance, you're probably still going to discuss the parking component. Just to preview for people, I have a feeling that's what's going to happen. But in the interest of moving this along, unless there are any other questions for the appellant, thank you, and we'll see you in a couple minutes. So let's, unless there are any other questions for staff, let's move ahead.
I have one question for staff. So if we decide not to hear the issue on parking because they lost a 10-day right, do we still need to hear then about the dumpster enclosure?
Well, they came in with a separate appeal on the dumpster enclosure. They tried to appeal it to the Housing Appeals Board, and I told them that wasn't appropriate, that they needed to appeal to the Zoning Board of Adjustment on the dumpster enclosure. So they did file an appeal on that. So the question, if you find they've lost legal non-conforming rights, it will make the dumpster enclosure issue a little easier to get through because but we'll probably have to go through the hearing on why they lost their legal non-conforming right on the dumpster, which affects the parking. It's all rolled into one.
Okay.
Sue Ann, I have a question. The appellant mentioned that there was some back and forth communication. Did that happen after the letter was given and within the 10 days?
There were not within the 10 days, but there were a number of emails after the January letter that went back and forth on this issue, where we're talking about rental certificates that haven't been issued because they don't have the parking and the dumpster enclosure. They've been told to bring in a site plan so we can review the deficiencies, so we can figure out how to get it into compliance. They have failed to do that. The parking issue, when they bring a site plan in, won't be heard by you anyway. It will be heard by the zoning board or the
Planning and
Plan
zoning.
and Zoning Commission, and if they want to submit a site plan that says we don't have any required parking needs off-site, they can take it to the Plan and Zoning Commission, and they can decide if they need off-street parking.
What was the date of their letter?
January 22nd.
Wait a second.
All right. Any other questions for staff?
So is that January 22nd of last year then?
Yes.
Okay, not
2019,
today.
yeah.
Okay.
2019.
Okay, I just want to make sure, because I got confused on dates, if they waited a whole year or, okay.
All right. So on this question, I guess I'd entertain a motion, unless there's further discussion that we all think is necessary, but I'm kind of inclined to move along so we can get to the substance of the debate we're going to have, which I think will probably include the parking. Any motions?
I'll move that we not accept the appeal because they've lost their 10-day right.
I will second.
Okay. Is that clear enough
The
for
parking
the
appeal,
record?
yeah.
Yes, it is.
So the motion on the table is that the appellant has waived their right to appeal the determination in the zoning enforcement officer's letter of December 2018. That's been moved, seconded. Any discussion on that item? All those in favor, raise your right hand and say aye. Aye. 6-0, it carries. Then we'll move into the substance of the rest of the appeal.
So we're going to talk about the dumpster enclosure. This is the area map. We got one card. And that's the property boundary, and if you'll remember, this used to be all held as one. They sold the two houses, came in with an easement, and the board upheld the easement to give them that easement to use with the main part of the apartment complex. There's pictures of the apartment,
Can't tell if it's a yes or a no.
picture of the rear. And this is where the garage now sits. It was built for this house. The easement grants access across the property to the garage. And this is the garage. That's where the dumpster used to sit. Another shot. I'm also going to put into exhibits number 7, 8, and 8, and 7 and 8. Polk County Assessor is exhibit 7 for the apartment, and then 8 is the two houses from the assessor. After they sold the property, they came in to talk to staff, and they had a pre-application conference regarding how they could make this make this right with the parking, because they had sold off their parking lot, and they were told at that time that they needed a site plan, and it did not comply with the regulations of the district. They did come in Exhibit 12, they came in and pulled the permit for the garage and showed it was going to be a 2020 garage back on the back of the site, right there, which was previously where the dumpster enclosure was located. On November 25th of 2019, in Exhibit 13, I explained that the appeal couldn't go to the Housing Appeals Board, that it needed to come here, and that it had moved from its primary location as shown on the aerial photographs, and that they needed to bring in a site plan and show where the dumpster enclosure would be located. That is what we're here on today, is that appeal. They wrote a letter to the board on January 3rd of 2019, which is Exhibit 14. I don't know if you've seen it, so I'm going to pass it around for you to review. So I think that sort of the most telling thing is aerial photographs from, this is 2002, shows the dumpster back in the back where the garage was previously, is now located. Exhibit 16 is 2004, again shows the dumpster in the rear of the property. 2006, same location. That's Exhibit 17. Exhibit 18 shows the same location. In 2009, in Exhibit 19, we have another picture where the dumpster is in the rear. Number 20 is 2010. Number 21, 2011. All of these show the dumpster in the exact same place. Exhibit 22 is 2013. Again, the dumpster is back where the new garage is. 2023, a little fuzzy, back in the back under the tree. Exhibit 24, 2017, again, back in the back. And 2018, Exhibit 25 shows it in the back. So, kind of the history is, the AHC bought the property in 2017. It contained all 3 lots. They sold 2323 Crescent Drive and 2320 Crescent Drive on November 7, 18. And with the sale, they sold off the parking area and the location where the dumpster was located. Here's Exhibit 25A, and it shows, here's where the garage is going to be. That was the existing parking before it was sold off. So 26 is a copy of the easement agreement that was previously upheld by the board, and it says that the parking easement for the limited purposes of constructing, replacing, repairing, and maintaining the parking area as a parking lot for the ownership operation of the apartment building, including a trash enclosure in the general area depicted in Exhibit A. This is Exhibit A, shows the garage, and here's where they show the dumpster, right there. So what we have is, they also lost legal non-conforming rights. They sold it off. That broke the continuous ownership of these 2 properties to be used together. They didn't do the easement for 6 months, which gave them that right back, so it lapsed for 6 months, and pursuant to the ordinance, you can't let it lapse. And that would be, I'll put in the parking easement and egress, or easement, is Exhibit 26. So what we really have is two reasons that they lost legal non-conforming, well, they have lots of reasons, but 2 reasons that they lost legal non-conforming rights. They sold it off. That broke the legal conforming rights to use that area for parking and a dumpster enclosure. That broke. They let that use of that legally lapse for 6 months because it took them over 6 months to get the easement recorded, from the date of sale to the easement being recorded. Additionally, the place that the dumpster was now is a garage. So you have eliminated the space on the land use that the dumpster can be by building something else on top of it. So it has to move. There's no other way for it to go. Once it moves and it loses legal non-conforming rights to be where it is, we're requiring a dumpster enclosure. It's not because the dumpster can move around. It's because the place that it was previously legal non-conforming doesn't exist anymore because there's a garage there. And 2, those properties being joined together for legal non-conforming rights expired when they sold it off and lapsed for 6 months before they entered an easement agreement.
Can you show us the applicable part of the law that is relevant for this, for your determination?
134-1353, use of land and new structures in district other than in our district, refers you back to 134-1352B and 4. So it says a non-conforming use of a structure or land in combination is abandoned, the use of which shall therefore conform with use permitted in the district in which it is located. use shall be deemed abandoned if while such use has been discontinued, the owner of the property makes any change to their property inconsistent with resumption of such use. The building of a garage absolutely makes a change in the property inconsistent with the use of a dumpster at that site. You can't put it there. The land is, such as the land is sold or put to another use. Use was granted by an easement entered into 7/22 of 19, but the sale of the property was 6 months prior to that. So they were using them in combination for parking and for the dumpster enclosure. That was fine. They sold it off, so they lost the legal non-conforming rights to that portion of land here because they sold it off. Then they came in with an easement and said, okay, these two houses will grant them an easement so they can use this area for parking and the dumpster enclosure. We had a hearing on that, whether the easement was sufficient to grant that, and the board ruled it was. In the meantime, then, they built a garage where the dumpster was. They showed on this plan the dumpster was going to move over here. Now they're arguing that since the dumpster can roll around anywhere, that they can put it here and they don't have to build a dumpster enclosure. That's not logical. Once they lost the location for that dumpster to be in, and they can't build it there, and they have to move it, the code says they have to have an enclosure. So we're asking them to enclose it.
Well, but what the part you just read talks about abandonment, and it's in a context of use, not specific location.
Use of land, use of structures, and structures in any district. So it's the use of the land, which would be where they put the dumpster enclosure, is the use of the land.
I guess that's one way to read that. I'm not sure that that's the most reasonable way, but I guess we can talk about that.
Suann, I got a question.
Yeah.
Suann, so and I wasn't here, but when they came in to discuss the easement, was there discussion about the dumpster being enclosed at that time? I mean,
No,
was there
that
any?
wasn't a discussion that was before the board.
Okay.
And then could you go back to if they had applied for the easement and gotten it within 6 months, is your argument that aspect of their non-conforming use would still be legal? And it's just because of the 6 months?
If the easement would have been recorded and we would have had the decision by the board that the easement was sufficient to grant them the off-street parking, we might be in a different situation. But they didn't. They waited 6 months before they recorded it. And then I said, no, the easement doesn't give you the right to eliminate the backyards of the houses. And the board said, well, you can use the easement and it doesn't matter about the setbacks to the house. So then we get into the next phase where they've built the garage, which changes what the easement granted them the right to build that garage, but it further creates a nonconformity because it takes away the parking spaces that they should have had they not built the garage. We don't know, we can't decide what the parking ratios are because that's not before the board. It's a Chapter 82 discussion, and you already ruled that they can't discuss that. I think it gets too complicated if you overthink it. They sold off that right to have that dumpster there because they sold off the property. You later said, okay, they can use that as part of the structure, as part of the apartment complex. But they built a garage where their dumpster enclosure would have had legal non-conforming rights to stay. So then it has to move and it needs an enclosure under the code.
Can I look at this?
So the building of the garage was a trigger to, they changed the use of the land by building the garage, correct?
Well, that really changed the use of the land because you can't put the dumpster where it traditionally sits.
Did they get a permit for the garage, and was it addressed where they were going to put the dumpster at that time, or that?
The homeowner pulled a permit to build the garage. I have been consistently asking for a site plan to show where the dumpster enclosure is going to be. They haven't given me anything.
The garage doesn't belong to the apartment, it belongs to the homeowner.
Exactly. Yep.
On the easement property that we gave.
Yes.
This is so confusing.
Yes.
Yeah.
Are there other questions for Sue-Ann, or do you have a kind of a wrap-up statement? We're at
No,
about 15 minutes.
I'll wait till my rebuttal.
Okay, thank you. Appellant, welcome back.
Look, just to clarify, so the staff did state that we can't determine parking here. Simply, we have lost the ability to appeal the December 2018 letter, but it's a matter for a different day how many parking stalls are required for the party. That's what I understood, staff. It's an Chapter 82 issue that can't be decided today, so we'll determine the specific number of parking stalls at a later date, unless anyone has any questions they would like to ask me.
I don't think you're going to get that.
Now, with respect to the abandonment of a legally non-conforming use for the dumpster enclosure, staff talks about a lot of different facts, but she doesn't really analyze the requirements of Section 134-1353. And she read it verbatim, and there are two requirements. The first is discontinuance, and then a change that is inconsistent with the resumption. My client hasn't stopped using the dumpster. It's always used the dumpster. And until it stops using the dumpster, its legally non-conforming use remains. Staff doesn't have any support that the movement of a dumpster constitutes a discontinuance of use, and that's what needs to be decided here. My client has to discontinue the use of the dumpster, not the use in a specific location of the dumpster prior to an abandonment of its legally non-conforming use. And in this case, it's simply moved the dumpster about 8 to 10 feet to the south, but it's always used the dumpster for the property.
Questions?
I mean, I see the law a little differently. You know, it doesn't apply to just the dumpster. I mean, it's the whole land, it's a whole thing. But what is the client's objection to just enclosing the dumpster? What's their objection to that?
Staff has made it. Sorry, you may finish. I don't want to interrupt.
I'm going to say because it is a benefit. It keeps it's very windy here in Iowa. Keeps garbage from flowing around the area, and it does make it more attractive. So what's their objection to building a dumpster?
So this is going to roll back into the parking issue, so I apologize. But as you may recall from the first time I was up here, my position was and still is that parking requirements is based upon the application of a site plan. Whenever we file a site plan, city staff is going to, I presume, take the position that we have insufficient parking. And that's not the position, that's the correct position. There's no legal requirement that requires my client to file a site plan. It's a decision that is within my client's right when it is made, and it doesn't want to file a site plan right now.
Well, his objection is he doesn't want to take away parking by putting up an enclosure.
That's one of the objections. The other is it's my client's determination when it files a site plan, and unless there's a requirement that it has to file a site plan, the city should not be able to force it without a basis in the law to file the site plan.
So what he's really objecting to is to doing a site plan.
My apologies, could you repeat that?
So what he's objecting to is the site plan.
What he's objecting to is staff's position that he's lost his rights, his legally non-conforming rights. My client has legally non-conforming rights, and the requirements under the law to abandon those legally non-conforming rights are that he has to stop the use, which he has not done, and then there must be a change that's inconsistent with the resumption of the use. Both of those must be met, and my client's never discontinued the use of the dumpster.
Can you turn this, because I know it's in your letter.
Which one?
Or I don't know if maybe it's not in this letter, I guess, but your letter that got passed around does cite the actual part of the code, and for some reason it's not in our packet, but the part of the code that deals with legal non-conforming use, because I think that is helpful to actually see.
Nathan wants to see it.
Well, let's put it up for everybody.
Okay. Oh, okay.
And I don't know that it's necessarily for you. I think it's just going to be helpful for the board, but
So this subsection B states just what non-conforming rights are, and what that says is whenever there's a change in the zoning code that creates the property that causes the property to be out of compliance, nevertheless, the city's not going to require property owners to take affirmative actions to bring it into compliance. Rather, they have a right to continue the property as it's always been used. So you have a legally non-conforming right until you abandon that right. And abandonment, the applicable subsections for abandonment in this appeal are subsection 5 and subsection 6. And as you can see, each of these requires a discontinuance of use prior to abandonment arising. And staff hasn't taken the position that my client has stopped using the dumpster. Rather, they've taken the position that the movement of a dumpster, which has wheels, which gets moved every week when it gets emptied, constitutes an abandonment, a discontinuance, and that's simply not the case.
Where is it generally located? Is it right next to the garage?
I believe they've moved it, they have not moved it significantly. So it was located where the garage was, which is on the adjacent landowner's property. And now they've moved it within an arm's reach of the garage, I believe.
Okay.
Other questions for the appellant? Thank you.
Thanks.
Anybody here, I guess, to speak in support of the zoning officer's determination against the appellant? Anybody here to speak in favor of the appellant? Thank you.
Speaking.
No, it's your turn.
City of-
Yep, just name and address and we'll get going.
Steve Corey, owner of Ingersoll Properties, which has 3305, 3307, 3309, 3311, and 3313 Ingersoll, adjacent to the apartment building. I appreciate the staff going through the effort of providing a 26 exhibit proposal on this matter, because it shows how thoroughly they went through. The Reed Apartments willingly entered into an agreement with Owen LLC to sell those 2 units for $250,000. Whether it was not through proper determination of where the landlines were, then that's what caused them to enter into an easement agreement. So I assume they never had any non-compliance letters before they sold the property. By making that choice to sell the property and gain the financial benefit, then they became under non-compliance. I did receive a letter from a representative of Reed asking if I would cooperate with them by allowing their tenants to use my dumpster. I said that really didn't make much sense. The only compensation they were offering was to pay for my tipping fees, which is about $1,000 a year. The liability of having that many people come onto my property for the purpose of dumping their trash didn't make sense. But we do have a common property line, and I offered to grant an easement without cost for them to use that to build an enclosure on several different locations. I never received any response or anything like, a site plan or even where do you propose to build it. There is a piece of land that we were actually sued for someone that trespassed and injured themselves. And I thought, let's finally cooperate and make this a better area. And I'll be happy to grant you easement for my property, again, without cost to build an enclosure here. Or further towards the front of the building, I would grant that land as well. So there's many places where they could build an enclosure. I think just the choice not to is not sufficient. And again, they were not forced to sell. They choose to get the $250,000. That created a problem of noncompliance. So I think they should have to do whatever they can to be back in compliance.
Could you find in that stack of papers the map of the area we're talking about, just so you can point out to the board what property you own?
So
Ingersoll.
this property where Cigar Source is, a duplex, solar loan and sales, is these two properties. And then our common border is right there.
Okay.
And this particular corner right here is where I propose that we build an enclosure. And as it is, my property line actually goes into part of an area that the garage is using as well, that I again haven't raised an issue with.
Thank you, Steve. Are there questions? All right. Let me make sure that I got the procedures right. So would it be Sue Ann next, and then?
Yes,
And
should
then-
be the next one
okay.
to speak.
Real briefly, for clarification, under 134-1352, 2, no nonconforming use shall be moved in whole or in part to any other portion of the lot or parcel which was not occupied by such use at the effective date of the ordinance adopting or amending the chapter. So they can't just move that dumpster from the place that it was always established to be to another portion without violating the code. Number 2, they have lost their legal nonconforming rights to the use of the area when they sold it off. That was proof of an attempt to discontinue the use. They rectified it later with an easement agreement that they entered into, but it was 6 months after the sale. Any use that discontinues for 6 months in a commercial zone loses legal nonconforming rights. So either way, you can argue it either way. That when they sold it, they lost the legal nonconforming rights. If that argument fails, when they sold it, they discontinued it by selling it and didn't reestablish it for an easement that they entered for 6 months. It's lost its legal nonconforming rights. They can't move the dumpster to a new location based on code without now complying with the requirements to enclose it. They don't get to decide when they're going to bring in a site plan. The code tells them when they need to bring in a site plan. This is a situation that absolutely needs to bring in a site plan so we can see what's going on out there. Chapter 82 demands it. You can't override that. That's a different chapter. You don't have the right. It's my argument that they have to put in a dumpster enclosure.
Hey, Sue Ann, I've got a question. By not submitting the site plan, they're basically saying they don't agree with what you're trying to do. And if they do submit the site plan, basically they're saying, okay, you're right. So now we're going to have to, is that how you see that?
No, I don't see it that way. If they submit a site plan and they say we don't have any requirements for off-street parking, the P&Z gets to decide whether they have requirements under Chapter 82 for off-street parking.
No, I'm saying they're not submitting the site plan because they
Yep.
disagree with what you're doing.
Yep.
And by submitting the site plan, they're basically then, and maybe I'm missing something here. They're, I guess, basically saying, okay, you're right, and we need to get this figured out. So what they're doing is they're objecting by not submitting the site plan.
That's one way to look at it, and that could be litigated and probably will be at a later date if they don't submit a site plan.
As far as the dumpster goes, all right, there probably isn't a dumpster in this town. Well, I shouldn't say that. Most of them that I see in situations like this are on wheels. So the fact that it's on wheels doesn't matter anything. There ought to be an enclosure around this thing. Whether they want to locate it somewhere else or not, I think if that's from a convenience standpoint for the property, let them move it. Just put an enclosure around it. I mean, somebody built a garage there, we moved it 10 feet, okay? But I'm just saying they ought to have to build this enclosure. So I hear what you're saying, I'm gonna disagree with, because they rolled the dumpster 10 feet means that now they're out of compliance. That's, to me, from my way of thinking, is, that's pretty punitive.
We have
But-
argued this same point repeatedly.
No, I know, and you gave us 15 years worth of history where I see a picture where a dumpster sat. Now there's a garage there. I'm saying, and I'm not taking a side here other than there ought to be a dumpster enclosure around this thing, whether it's located next to the garage or it's on the other side of the property. I don't care. There ought to be an enclosure around it. Everybody talks about being on wheels, big deal. Yeah, they're on wheels. That's probably easier for the guys dumping it. So I'm just saying we need to figure out, and this is a really complicated situation. I'll give you that. And I think some people are playing from a convenience standpoint or from their perspective, well, we don't have to do this, and by not doing it, then we've got a case. And I don't agree with that either. So we need to get something cleared up today because we've spent way too much time on this thing, my estimation.
We're not telling them where to put it, we're just saying to put one up.
Well, yeah, and
Even their
I mean,
agreement, even their agreement on the easement places it in a different position than it's traditionally been in, which it's a change. They can't move the dumpster around on the property without triggering the enclosure.
but if they put an enclosure up, they won't be able to move it around because they got to keep it in the enclosure. So
Yeah.
that's like putting a fence around my yard so my dog doesn't get out. So if they put the enclosure up, they're not going to be wheeling it all over the property, I don't think. Because
Traditionally, they haven't wheeled it all over the property. They've had it in one location traditionally.
Well, I got it. Now there's a garage there, so they moved it 10 feet or whatever, however far they moved it. I think we're splitting hairs there. But
Well, the legal definition of land use is that you can't take a legal and the dumpster is legal non-conforming, not enclosed. You can't move the non-conformity to a different location on the lot, which they did. That triggers the enclosure.
okay, so then I'm just saying, let's make them build an enclosure.
That's what we're discussing.
Any other questions for Sue Ann?
Now, I'm not arguing with you. I just want to.
I think that's the time when we close and
I have a question for
that's the whole deal, is we're voting on whether they need
Yes.
enclosure or not. I
That's
mean,
the only thing that's facing us today. But I've got a question for the appellant, based on the language that Sue Ann just put there.
Sorry, go ahead.
Yeah, what's your response to the relevant language that it's not there anymore, but just under that top sheet of paper to the right of you, this part of the code that appears to describe use of land and the restrictions on non-conforming use, including a restriction on moving that non-conforming use to another portion of the lot or parcel that wasn't occupied by such use as of the effective date.
So I think we're in agreement that 134.1353 is the abandonment provision for commercial property, for NPC property. So I would like to go to that first, if it's in here. It's not.
I think it's on the
Well, I
back
guess-
back of the first page.
Yeah.
Or
That's what I want to talk
Is that property zoned commercial or is it zoned residential?
My client's property is NPC, which is commercial. I guess my response to that, I have this provision. It's got a bunch of my work product on it, so I'd prefer not to put it of record. Does anyone have a copy of 134.1353? It's all in here.
It should be in there. Open payment.
Oh, thank you. Thank you.
Find it.
They were zoned at the time of violation.
So there's a difference between a non-conforming use of land and a non-conforming use of land and structures, right? My client is using the land appropriately. It's authorized to use the land for multifamily purposes. That's a use. Now, the non-conforming use of land and structures is what is at play here. So if you look at 1353 subsection A, which incorporates 1352, as the zoning enforcement officer noted, it states non-conforming uses of land, not non-conforming uses of land and structures. Whereas elsewhere in the code, it references non-conforming use of structures, if you would look at subsection B. Subsection B doesn't reference back to 1352. So the movement language cited by staff in 1352 doesn't apply to non-conforming uses of structures and land in combination.
so your position is you could move a non-conforming outhouse around your property.
If it's on wheels, yes.
What would the distinction be for wheels?
Well, one seems readily movable, whereas the other does not. And if I may, I don't know if I may continue on with other
Yeah.
thoughts as well. I think whether a dumpster enclosure ought to be built and whether a dumpster enclosure is legally required to be built is what needs is really the issue, and this board's role is not to determine whether one ought to be built, it's whether to determine one is legally required to
Right.
be built.
All right, any other questions?
I just can't really see,
Can you pull up you just move it so we can see the section that you're referencing? The A and B?
Yeah, so staff references subsection A, which pulls back to 1353, and then
To 1352.
1352, thank you, and then references language in 1352 to say movement of the dumpster constitutes an abandonment. But subsection A only applies to non-conforming uses of land, right? Whether the use should be single family, whether the use should be commercial, whether the use should be industry. It doesn't govern non-conforming uses of structures, of land and structures in combination.
Can you pull up the second part now too? The page that's on the right there, because that seems to have some relevant language that's good, thanks.
Correct. In my letter, I think we're in agreement that subsection 5 and subsection 6 are the ones that apply to this case.
And that's what you pulled out in the letter. Okay. This is, any other questions for the appellant? We will close the public portion of this great debate and move to board deliberation. Any comments?
Well, I think we're
From my
really
colleagues.
splitting hairs on non-conforming use of land or non-conforming use of structure. I think a structure on the land, it becomes part of the land. We talk about sheds that are not permanently attached to the ground. They're movable sheds and where they can be located and how big they can be and everything else like that. So
I think the point is, if it's a structure or land and structure, either way, their argument is that the language that Sue Ann pointed to doesn't apply. It would only apply if it's land only.
okay.
Anybody want to make a motion?
I will make a motion that we move to support staff recommendation and require an enclosure.
I will second that.
Okay, there's been a motion and a second that the board upholds the determination of the zoning enforcement officer that the property has lost its legal nonconforming rights to have a dumpster without a compliant enclosure. All those in favor, raise your right. Well, any discussion? Yeah, sorry, go ahead,
Can
Dave.
we put a timeline on this? When it's done?
Within 6 months?
They need to just do it, right?
Can we say it needs to be done within X number of days? Well, here's what I don't want to do. This thing could exist into perpetuity the way the conversation goes, the way they object. Right?
I guess it's more of a.
I mean, we're already, there's a letter that Sue Ann wrote that's, 15 months old? 14 months old? Something.
Yeah, but I think it's immediately enforced.
Okay.
Then it's up to how we get compliance.
Okay. All right.
Any other
That's all I need.
debate and discussion? All those in favor, raise your right hand, say aye.
Aye.
1, 2, 3. All those opposed? Oof.
Doesn't pass.
Doesn't pass.
That's right.
And so, we don't have another vote, right?
No, you don't.
Okay.
We need to have 4 conforming votes, so it does not pass. This,
And it's not likely an alternate would pass either.
right, because it would just be the exact opposite of this particular one.
Right.
There's just two choices here, either yay or nay, and if one doesn't pass, then the other would be the other motion. So in this case, it does not pass.
So do we bring it back up for discussion to revote or see if we can, I don't know.
Wait, but that would
Right
mean,
now,
that would mean
it's-
if I had made the motion and then it was defeated, would the obverse be true? Like, that can't be it can't be just whoever makes the motion and then if they don't get 4, then the opposition wins.
But is there any other choice in this particular situation?
So right now, we just let it sit and,
Who brought the appeal? The city, right?
The city
we
brought
can't
the
appeal,
appeal
because
in
right
this
now,
case.
we're nothing.
I believe it would take 4 affirmative votes of somebody to overturn the zoning enforcement officer, so. If the
Okay,
so right
that's
now-
the posture.
Yeah.
Okay.
So basically,
lack that.
by not having 4 affirming votes to overturn the officer, we're affirming her.
Okay.
Okay.
Just to,
Default, right?
yeah.
It's not
I think I would like to have, actually, I would like to have that vote just to make it crystal clear that we don't have that. So it's, so I'm going to move that we deny the determination of the zoning enforcement officer.
Which means you're not requiring a
Right,
dumpster enclosure.
right. And Justin seconds that they have not lost non-conforming use. There's a motion and a second. All those in favor say aye, raise your right hand. All those in favor, or all those opposed, raise your right hand. All right. So the zoning officers, because it was an appeal of the zoning officer's determination,
And because it takes 4 votes to overturn that, and this motion did not have those, then she is not
her determination stands.
correct.
Thank you, everybody, for 70 minutes of discussion and determination. We'll move on to the next item, the last item, item number 6, which is an amendment of a conditional use permit in the vicinity of 608 Southeast 30th Street.
Thank you.
On the road.
Oh, I'm sorry.
Yeah, so in the heading of the staff recommendation was a scrivener's error of cut and paste.
I gotcha. 919 Southeast 21st Street.
So on the agenda, it's correct, but in the heading of the staff report in the packet,
Oh,
it
I
was
see.
incorrect.
Oh, okay. So which one
The
is
item
it?
number is correct.
And
the
all the
remaining-
rest of the information is correct.
The remaining contents is relevant, yes.
Okay.
And so we will correct it for the record. I don't have copies to pass out with it corrected. Okay.
Got it.
So the correct address is 919.
Yes, 919 Southeast 21st. So, and I'll go over that here.
Okay.
So the property in question is in the gold boundary. I guess I want to, if you look at that relevant zoning history component of the staff report, their first consideration was this original piece up in the northeast corner. Then years later, they incorporated this portion. Then they went through a process where some of the right-of-way ended up being vacated of Southeast 21st Street, and then they went through a rezoning process to rezone land so that they could ask for a conditional use then to incorporate this portion right here. And so the situation is that they had 3 active orders that were enforceable, and each one of them had different provisions applicable based on the situation at the time, the codes that were in place at the time, which were modified over that period as well. They are now working with staff to try to come into compliance. They had enforcement ongoing. Some of the conditions of these various orders were not kept in compliance or brought into compliance initially with the decision at the time. One of those pieces being not having a site plan for the expansions with some of the elements. So in an effort to sort of get this cleaned into one site under one common conditional use. They filed under the previous code before the December 15th effective date of the currently enforceable code for a conditional use permit. Just so you're aware, under the current code, it would be the same thing. They would have the I-2 zoning, and we would still be looking at a conditional use process for a junk and salvage yard, basically. So really nothing in the, from this particular scenario doesn't really change given the new code. They happen to file it under the old, so they didn't have to try to sort through any changes in the code sections or anything like that. But essentially what staff did then is review, okay, what elements of this are in compliance, what elements aren't, sort of what changed in the interim. I guess one of the big things that changed in the interim was how we looked at dustless and durable surfaces for outdoor storage use and junk and salvage uses. The big thing is the intent of them is to not generate dust. City of Des Moines is like an attainment city or community where we have to keep under a certain level of particulate in the air. And one of the areas that's really problematic in the city is this particular area of the city. The industrial users, a lot of that was due to both unpaved city roads, public road surfaces, which prompted modifications to how we treat and maintain city streets that were, not paved streets at the time, and also requiring that storage and so forth occur on dustless surfaces, and parking and driveways be paved. The other piece of this is the best practices for salvage yards that are put out by the Iowa DNR, which was sort of a basis for a lot of our regulations that we applied to junk and salvage yards in our zoning, points to whenever vehicles are brought into a salvage yard and they drain fluids and so forth, this needs to occur on a impermeable surface, which paving is pretty much the only thing that can do that, unless they're going to put down big sheets of steel or something, that doesn't allow the fluids to get into the ground. So one thing that we wanted to make sure was that indeed they were keeping their parking, their driveway access from the street into the site, and their fluid, their intake area in compliance with that pavement or impermeable condition. And then we wanted the remaining piece to be in compliance with the dustless and durable surfaces as determined by our city engineer, which, we've been through this exercise a lot of times, and what we know is that recycled asphalt product is the material that is acceptable to meet that test. So prior to them, other salvage yards, outdoor storage situations, the standard is recycled asphalt product. It's an emulsified material that's milled off the top of asphalt pavement surfaces, and it's a commodity that is as easy to obtain as gravel, which is a dusty material. So we don't want these storage areas to be maintained going forward with a dusty material. We want a dustless and durable material that doesn't wash away. And by emulsifying, it also stays cohesive or sticks together, doesn't wash away from the site and have to be maintained frequently. So that's another piece to it. So that was in previous renditions. Now, the question was always, was it only applicable to this consideration for the new expansion or the existing site? I suppose there's some argument to be made one way or the other. I think staff just wants to get something that is in compliance. I would say that we're not pushing for things that would be applied to something brand new if this were built today. I think there's additional things that we would ask for such as open space, a lot more open space. What we did is we looked at the previous orders and tried to incorporate as much as possible from those that was reasonable and not onerous, both, and still achieved what we're trying to do, which is essentially get some open space, some shading that we get through landscaping, and this surfacing that is acceptable and doesn't create impacts on the surrounding area. So when you look at this list of staff recommendations, it really is kind of a condensation or a collection of the three orders together. One thing that was on the actual application or the appeal was the variance for waiver of paving requirements. Staff doesn't believe they meet the test of hardship to grant that, but we believe that they can achieve the intent of the ordinance with the durable and dustless material for the storage areas going forward, and that would not need that variance. So we are recommending denial of the variance that just outright asks for the waiver of the paving and requirement altogether, so that based on that finding. And so, but we believe that what they're able to do fairly reasonably moving forward is use that dustless material, as they have to maintain that surface over time. We're not asking them to go in and dig out the existing material and get rid of it and replace it. We're just saying over time, as you maintain this surface to keep it usable, we want that material. So if you look at the staff recommendation, there's 8 pieces of this. They may be asking for a slight modification in my interactions with their attorney, and we're not going to. I don't think we're going to stand away or stand in the way of that. I think we're of the same mind that it meets what they're asking for, meets the same intent of what we're trying to achieve. So I think they're just concerned that the way it reads is that we want instantaneous application of that material for storage areas, and that really wasn't the intent. It was more about making sure as we move forward, everything is maintained with that material. So number 1 is that we want to make sure it is in accordance with the site plan. So yes, we do still need a site plan of record that we can enforce over time going forward that reflects the items that need to be done. And so we did not get that in previous actions of the board. It also required a site plan. So I think we still are keeping that piece into it, and we do want that. In all likelihood, that would be professionally prepared. It doesn't technically have to be professionally. There's nothing requiring it to be professionally prepared, but I think something of this magnitude is probably advisable. Number 2, the provision, all driveways, parking lots, and required impermeable areas for fluid recovery and dismantling shall be surfaced with Portland cement concrete or hot mix asphalt. So cement, 2 types of paving surfaces, either one is acceptable. And then all other areas for storage shall be surfaced with pavement or recycled asphalt. So we don't want to preclude them from paving these areas if they want to, but the recycled asphalt product going into the future is an appropriate material to be maintaining these with. 3, any encroachment of junk and salvage vehicles onto private property to the west shall be removed. So if you look at, there is a slight area right here that I believe they're in negotiations with the adjoining owner over whether it's theirs or they're going to purchase it. But at the present time, what's of record with Polk County is that belongs to the other location, which is also a storage yard, junk in storage. It's not a vehicle salvage, but it's for scrap material. Number 4, any use of the site for a salvage yard shall be screened by a minimum 8-foot tall metal fence with uniform color and material. All fences shall be maintained in good repair. This carries from the previous orders. I believe they're already in conformance with this for the most part. They may have some places they need to keep it maintained. That's just getting carried forward. Number 5 speaks to kind of combining some of the landscaping requirements that were previously asked for with the previous decision and orders. One of the things that we've discovered that's not very practical, this is a levee right here. And one of the orders asked for trees to be spaced along this property line. And one of the things we actually don't want to see now is root systems getting into the toe of our levee. So we're not pushing for any trees in this request or this recommendation. We do think, however, that they still can provide spacing of trees 40 feet on center on these property lines. And then another piece of it was the way it was listed in the order was 100 by 120 foot area for landscaping. I think we would rather be flexible, and that was actually to be applied in this area at the time, which now they're occupying with another expansion. So I think we are open to we thought as staff that getting it somewhere up in this area where it's going to be more effective anyway, and also giving them the flexibility of how to shape it, just limiting it to the same square footage. And then what we did was apply the standard of one tree, one evergreen, and one shrub per 2,500 square feet of that open space, which ends up being 3 of each. Again, we don't think that's too onerous. The other piece of this is because they have a lot of vehicles in some of these areas, they don't get moved around overnight, but they do over time get processed through and removed as the parts get taken off of these. So we're recommending a 2-year time frame, the length of the decision and order effectiveness anyway, to come into compliance with that if they want. The idea being that they can incrementally displace areas that are currently maybe storage or out, for junk vehicles or for other purposes, and get the landscaping in incrementally during times when it's appropriate to plant landscaping, that type of thing. We think 2 years is a reasonable amount of time to do that. Number 6 is pretty standard language. Any dismantling or repair of vehicles shall occur only on impermeable surface with adequate provision for collection and disposal. It's a little bit redundant to the number 2, but very clear that area can move around possibly. So we want to make sure they're doing it on a impermeable surface that meets the intent. Number 7, junk and salvage materials should not be stacked higher than the perimeter fence within 75 feet of that. So if the fence is at the perimeter, they shouldn't be stacking higher than the fence until you're 75 feet away from the fence interior to the site. And then even then, we don't want to see it stacked higher than 25 feet, elsewhere within more of the center of the site. And again, this is really for what's visible from surrounding properties and the adjoining rights of way. Again, this isn't inconsistent with previous conditions of the previous orders. And then number 8 is a provision that comes right out of our standards for junk and salvage yards. In both the code we're considering, the previous code, and in the current code, is the best practical control technology shall be employed to minimize these impacts of offensive odor, dust, smoke, gas, noise, or similar nuisance. And then there's the number 9, which if something isn't, compliant over time, the zoning officer can bring it back to the board for reconsideration.
Thank you, Eric. Any questions for staff?
Eric, is
is this 8-foot fence right up to the boundaries on the, as far as the lot lines go all the way around?
I think in most cases, yes. When it comes to the trees, they can be planted inside the fencing.
Okay.
Yeah, usually you need about a 10-foot area to really have an overstory tree.
Yeah, so what you're asking for them to do is you're asking them to sacrifice some of the storage internally to put some trees and landscaping behind an 8-foot tall fence.
Or shift it around. I think they probably don't have to sacrifice too much storage area. If they can over time, as they get vehicles crushed or whatever, they start freeing up these areas that need to be planted.
Is this whole area pretty much salvage yards, it looks like, all the way around it?
Yeah, there's a building, and they can probably answer some of these questions. There's a building here.
No, but I'm just looking around the whole area,
Yeah,
the neighbors.
Well, yes, so there's, to the north, the city's public works yard, and they have storage of
Yeah,
materials over here. In fact, some of that recycled asphalt would be over here too, because the city uses it. I think Croto is to the northwest, recycling's to the north, and scrap processors, appliance recycling, I think, is straight to the west.
okay, thanks.
Can you explain for me what recycled asphalt product is? Is that loose or is that more like
It
a
is
surface?
loose. It's a loose material you've probably seen these machines when they resurface a street, go in and shave down the crown of the street, and that material gets collected, and it has asphalt emulsification as part
So
of the
water
material.
can still trickle down to that and not be all solid surface water will all run off?
Yeah,
Okay, that's what I was worried about.
A little bit, yeah, so it also drains a little better than just
Okay,
permanent paving, yeah.
okay, thank you.
Hey, Eric, when, in 2012, when the board approved the conditional use permit and those
Yes.
conditions were put on, were those conditions followed?
I think some of them were. I think the site plan was not. I don't see any evidence that the landscaping was provided. Or if it was provided, it wasn't maintained. So I would say there was some, this is why we have it on enforcement at this point. So.
Okay, thank you.
So this came to us today as a result of enforcement.
Yes, and we have been trying to work with them. So we know this is a business that's active, and it's not something that's just kind of a part-time situation. It's a thriving business but we just need to get these things into compliance, and we're working with them to try to get that as easy as we can, I guess.
Thanks.
Thank you. All right. Applicant or representative? You have 10 minutes.
Thank you, Mr. Chairman, members of the board. My name is Brian Meyer. I'm their attorney for Y'all Salvage. Address is 1217 Army Post Road, Harding Law Firm in Des Moines, Iowa, 50315. I'll just go through the staff recommendations and point out we have been in discussions and recognize the enforcement factor that is involved here, but we have been in discussion with the staff on how to best proceed. And essentially what you are doing is you are eliminating 3 conditional use permits and rolling them into 1, which I think benefits the city in terms of having 1 document to go off of, 1 site plan to go off of for enforcement purposes. We agree with all of the staff recommendations. We have no problems with them, except for a few minor changes that I talked to Mr. Lundy about this morning. Number 1, we have no problem with. Number 2, sentence number 2, which I think Mr. Lundy referred to, the concern that we had was on number 2, all other areas for storage shall be surfaced with pavement or recycled asphalt product. Our concern was he can't do that now. That would be cost prohibitive. And the agreement or the compromise I think that we came up with the city was that the maintaining, Mr. Lundy referred to as maintaining and moving forward, that as it need to be replaced, that it would be replaced with what the city is recommending here, the recycled asphalt product. So They can't go in and change it to recycled asphalt product now, but as the replacement product comes in, we are certainly willing to do that. That's not a problem, but it would be cost prohibitive to do it now. And I think the intent, Mr. Lundy stated, was that it would be moving forward and not a requirement now. Number 3, I noticed actually while Mr. Lundy was presenting, just from the matter of, there's a very small part of the property that they are using now that they didn't realize they didn't own. Some of the deeds in that part of the town are a little sketchy. So they thought they bought the property that is, if I can point it out here, this area here, that's what's referred to in number 3. They are in the process of purchasing that product from the adjacent property owner. And I just want to make sure number 3 was clear. I think as it's written here, honestly, it's ambiguous in terms of any encroachment of junk and salvage vehicles onto private property to the west shall be removed. Well, it's all private property. I think what you meant to say was the property of the adjacent landowner, not randomly private property, because they are private property. Just kind of a lawyer thing there. Which we don't have any problem other than that with number 3, because they're going to purchase the property anyways, and it'll be part of the site plan. And if we have to come back before you as a board, we can do that. Number 4, we have no problem with. Number 5, we really don't have a problem with, because we'll just plant the trees within the perimeters of the fencing. I think the concern was, when I looked at it this morning and talked to Mr. Lundy, that the concern was that the fence is on the property line and there was no opportunity to plant outside of the property line. And so if they want us to plant within the property line, the 3 overstory trees, 3 evergreens, and 3 shrubs, I think we're okay with that. Everything else, 7, 8, 9, we are completely fine with. I just would ask the board to modify those 2 sections to include under staff recommendation number 2 to state that it's moving forward on the recycled asphalt product as that needed to be replaced, and then also just to recognize the fact that number 3, maybe rephrase it as onto the adjacent property to the west. It just sounded weird to say private property.
Yep.
I understand that.
So are you dropping the variance request then?
Yeah, no, we're not asking for a variance.
Okay.
We agree with, and that would go to number 2.
Right.
So we're dropping that request, and we agree with the staff recommendations.
Great.
As long as we can agree that,
Immediate implementation.
correct,
Yep.
Mr. Chairman, as long as it is not a requirement that they go out and do it now, that they do it as they replace what's there now, which I believe is concrete and gravel, as that needs to be replaced. We have no problem dropping the request for a variance on that.
Is 2 years an acceptable time frame?
Yes.
Okay, perfect.
You're referring to number 5 on the,
Well, no, I was referring to replacing the number 2. As some of the gravel area needs to be replaced, so you replace that with the hot asphalt product.
well, I think the concern with this on 2 years would be
Well, he mentioned that.
we don't do I don't think we can do 2 years on that, because some of it may not be replaced for 5 to 10 years as cars are moved and that sort of thing. So what we would ask is that as it needs to be replaced, they will switch over to the recycled asphalt product
How
and
do
not
we
put a time
determine
frame on
that?
it. Not put a time frame on it.
Because I know what Eric had mentioned in his, that's why I wrote down when Eric was talking, he thought that 2 years for that. But how do we determine as needed? I mean, looking for enforcement, I mean, we need to put some type of,
Sue asked that question too. I guess, it'd be up to the board to modify that. Our intent was, we know from time to time they're going to need, for their own purposes, to replace the surface or upgrade the surface to keep it usable for their purposes.
can we just say
Whether
that
that's,
as it needs replaced, we do it and
well,
not
that's
put
the
time
way
frame?
I wrote it into the staff report. If
Okay.
there's some desire to have it 100% by a certain time, that's reasonable, that's up to the board. But we were looking at it as moving forward, when they maintain that surface, we're not adding a white rock or something that's
Okay.
going to be a problem. Right now, as it stands, it's as bad as it will be then.
I was just taking notes off of what you had said. You had mentioned a 2-year time frame on that one.
But if you're
so-
wanting to have some assurance that it will all be done at a certain point in time, that would be something you'd have to
Okay.
modify.
Thank you. Yeah, sure, I'm
Come on
sorry.
back, sorry. We kind of interrupted you, so. Come on back.
If we could keep the language, and I know Sue just asked me about 10 years, but we would prefer to keep the language as it needs to be replaced, which I think was the city's intent to begin with. So we don't want to put a time frame on it simply because, again, there may be some areas that never need to be replaced or replaced within 10 years, but rather that as they're moving and need to replace that they know, if it makes the city more comfortable, they can't use, we can state that they can no longer use brick or concrete, but that we keep the language as needed on the recycled asphalt product.
Okay.
Other questions? All right, thank you very much. Just for kind of pro forma, if there's anyone here to speak in support of the applicant, raise your hand. If there's anyone here to speak in opposition or to comment any further. Any additional questions for staff? I guess I might have a quick one for Sue Ann on the enforcement piece. I kind of understood that you had suggested a 10-year timeframe, which sounds like that's not really workable for them, or they would prefer not to. Realistically, is that type of timeframe, does that really make your job any easier until it gets to 10 years, or would you have the same kind of challenges evaluating whether they're actually replacing as they should be over that 10-year time frame?
It would just be an end date that we would go out and see if it's done or not.
Yeah.
It would give us everybody understands it'll be done by here.
Yeah.
This is going to be a little challenging because they're behind a gate, and I'm
Yeah.
not going to be out there watching loads of whatever comes in. But if we see rock being brought in or seeing it spread on an aerial or something like that, then we would be in enforcement mode.
Okay.
I mean,
So can we just demand recycled asphalt, period? Unless they're going to put concrete pavement down?
you
And then we
could
don't
say
have to worry
that
about
not
somebody
that timeframe.
dumping gravel. I mean, look at this whole area. This is an industrial area. What's the surface on the city spot across? Is that gravel?
No, that's the asphalt product.
Or whatever. I'm just saying, this whole area, let's not micromanage this guy.
The only thing I would
Gwen,
do
you got way better things to do with your time than look behind an 8-foot fence to see if he's got a bush, in my estimation.
we would look at aerial photos and
Right.
and
So,
make sure that
I-
they haven't changed anything substantially.
And I think you can tell if they put down fresh rock.
Yeah, it looks
Generally
different.
Also, I think we can remove the time
I
frame.
mean, that's operating good faith here.
Okay, thank you very much. All right, let's close the public portion, move to debate.
Well, I think it's a good idea that I understand that it was under 3 different parcels and different rules and everything. It's going to be more streamlined for them. I am all in favor, and I would be willing to make a motion changing the rules or the staff recommendation for number 2 to say that they replace the stuff as it needs replaced and not put a time frame on it. For the hot asphalt and the Portland cement. And then on number 4, no, it was number 3, on the encroachment of the parcel of property, to say onto the adjacent property owners, property to the west. And then if they own it, then that's not longer the adjacent property owner, they own it. So I think otherwise everything else is fine and they're fine with it. So that's what I would like to make a motion on.
All right, we've got a motion from Lynn. Is there a second?
I'll second.
Second from Dave. Any discussion? And to be clear, they rescinded their variance request, so we don't need to address that. So this is the totality of our determination today. So All those in favor of the motion on the table, raise your right hand, say aye.
Aye.
Aye. Any opposed? No. Unanimous.
Yay.
The last item on the agenda that we need to complete is approval of the minutes from last month.
I'll move, Mr. Chair.
Thank you. Cindy moves approval. Any second?
Second.
Second from a handful of people that we can decide later. All those who were here last month who wish to approve, raise your right hand, say aye.
Aye.
Aye. Carries 5-0 with Lynn abstaining because she wasn't here. And I think that's it.